This is just between us,
Thank
right?
you all for coming. This morning we had your oral argument on the Cambridge v. Maklin lawsuit, and to stop here, we're going to have a panel discussion about what we heard this morning. I'm going to quickly introduce the panelists. You have their bios on your handout. On your handout, there's also a wireless info if you wanted to log into wireless. Restrooms are that way. My name is Laura Bertle. I'm from the library, and the library does welcome you all here. Starting at the far end, Jonathan Band. Next to him is Bruce Joseph. We have Tony Askew, Lisa Maklin, Steve Schaetzel, Michael Landau, and Brandon Butler is going to be our moderator today. So, turn it over to Brandon.
All right, and so thanks everybody. Welcome to the panel. We're doing a little post-game discussion here of the argument that I hope most of us just watched at the 11th Circuit Court of Appeals. But even if you were there, you probably need a little bit of background on the trial. And so I was going to ask, and Steve, since you were on point during the arguments, I thought Tony asked you, if I could ask you a little bit, no pun intended, to tell us a little bit about the trial and the basic facts of this case. What was going on in this dispute? Why did we end up here in the 11th Circuit?
So a little history, if you will.
A little history.
Several years ago, 4 or 5 years ago, the publishers began to complain to various universities about e-reserve systems. Georgia State was not the only school that received those complaints, but Georgia State was one, President Patton in particular, that decided that, that this was just too much. What had happened with respect to Georgia State was kind of interesting, is that for a while, the passwords that were in use that limited access to internal computers at the schools were not functioning properly. And the publishers, primarily through CCC, copyright clearances, were able to access the computer systems at Georgia State, and were able to look at what various professors were doing, what were being assigned, sort of thing. Look at the copyright policy, although you can probably find that on the internet. But we're able to look at a lot of very internal materials that were within the computer systems at the school and see what was being done by various professors. And they did, at that time, find some instances of a rather significant amount of use by professors of material. They made their complaints. Many of the schools that were complained about, I can remember when Texas was one of the ones that decided to change and take a license agreement, if you will, from the publishers. Georgia State decided that it was not going to do that it felt like what was being done was fair, and the decision was to defend the lawsuit. The lawsuit as filed, if you've ever read the complaint, was very, you might have heard Bruce Rich today talking about it. He made it sound like they had some very specific allegations. They had some very general allegations with just rampant copying, systematic infringement. They had 5 or 6 works identified, as I recall, specifically, but it was more a claim of just rampant infringement. We decided very early on to take a look at the guidelines which were in place at that time, and decided that it might be a good idea for the school and the university system in general to adopt a copyright policy that had more specific information about the fair use practices and the fair use provisions and the fair use right of all to make a fair use of a copyrighted work. A committee was formed by the chancellor of the university system. It was about 10 people, as I recall, of various schools around the state, referred to as the Select Committee on Copyright. That committee met 5 or 6 times to talk about issues. All of these individuals were very knowledgeable. They were primarily from the library community, very knowledgeable about copyright issues, and had some very good ideas and insights into what would be fair and what would not be fair. Out of that came a proposed copyright policy that was provided to the chancellor, and it was adopted. And we provided that to the publishers. interesting, earlier, even before the committee was formed, the publishers had somehow sensed that we were considering adopting a new policy. And when they learned of that, they insisted, and they were quite insistent about this, that if there was going to be a committee formed and if a new policy was going to be adopted by the university system, they insisted that they have a representative on that committee and that they participate in the process of formulating a new policy for the university system. That request was denied. When the policy was adopted in February of 2009, the publishers were very upset that the policy had been established and had been adopted without their participation. Their discovery efforts from the outset were in large part focused on activities in 07 and 08, back again when they were snooping on Georgia State computers and had learned of certain things, amounts of materials are being used. They asked a lot of questions about that material. They took some depositions of professors. We had proposed, slight digression, when the policy was adopted, we had proposed to the publishers that we suspend the case, stay the case for a year, so that the university community could become familiar with the policy, let the professors work with the policy some, begin to use the checklist, begin to follow these policy requirements. That proposal was rejected immediately. They began their discovery efforts. They took 3 depositions. The 3 professors that were deposed were not familiar with the policy. It had just been adopted a month or 2 before that. They hadn't used it, weren't familiar with it, weren't able to explain how they would use it. In later motion practice for summary judgment, the publishers complained rather harshly about the fact that these 3 professors were not familiar with the policy, weren't able to answer questions about the policy. And Judge Evans made a very specific finding that that was a strategic decision they made to do that, had not accepted the proposal to stay the case, chose to go forward on the basis of the policy as it was without the professors having any familiarity with it. And therefore, were not able to get from the professors any information as to how they would apply the policy and how they would use it. As a result of the discovery efforts, which was so focused on the activity prior to this new policy, we filed a motion for a protective order, and the initial request was denied. Judge Evans needed a little bit more information about how the discovery program was proceeding. We provided that, and she did grant that motion and entered a protective order in the case. You might have heard Bruce Rich today complain about that. They were very upset about that order because, yes, they did. They lost all of this information they had gained through their snooping activities at the university system. Her decision was that the case would be tried on the basis of activity that occurred after February of 2009 when the new policy was in place. We also got Kitty Cruz to come on board with us and assisted us as an expert. We had an expert report from him that was filed. They were very upset about the expert report from Dr. Cruz, moved to strike that report, and that became a very hot issue for a while. Judge Evans, as a result, interestingly, read his report to consider it and determined not to strike it. But as a result of their motion practice, she did then become very familiar with the provisions that he had detailed the subject matter of his expert report. But she decided she would not strike it and in fact indicated that she would look forward to hearing from him as the case proceeded. So it did proceed. We then did go to trial. The trial lasted it was extended over about 3 weeks. It was actually about 15, 16 days of trial time, something like that, which is a long trial. Copyright cases typically go up on motion practice. You'll have some affidavits, the facts usually not too much disagreement, and you'll have some motion for summary judgment. Case is decided, it goes up on appeal basically to de novo because it's a summary judgment motion. It's going up. We decided that we wanted the professors to be testifying. We wanted Judge Evans to see the professors. We wanted to be able to ask the professors questions about why they had selected a particular excerpt, what its relationship was to the class that was being taught that day, what was she or he trying to teach with that excerpt, and we thought it was really important for that to be done. We did start, Judge Evans had fallen a few days before this trial got started and had injured her hip and leg, and she was in a great deal of pain for the first week or so of the case. It was very obvious that she would come in, and they had to put in some handrails and some other systems to help her get to the bench, whatever. But we did proceed with the case. They obviously started. They called a few professors, 2 or 3 as I recall, put in representatives of the publishers, Cambridge and Oxford, and a representative from CCC. And then we had the defense. We put on a number of professors to testify. Then trying to think of any memorable events. I don't remember if there any particular significance other just it's trial work. If you've done it, it's hectic. You'll be meeting with the witnesses the night before. You're up late the night before, then you'll be trying the case all day, and then you up the next night getting ready with the next witnesses that you're going to be putting on. And it just proceeded to some closing arguments, and that was it. We waited obviously about a year for her decision.
Yeah, and you know, all that year I wondered what's taken her so long, and then we get the opinion, and it's 350 pages long, and I thought, well, there you go. And I wonder, and boy, you know, it's interesting. You hear these stories about these judges. Judge Baer, who handed down the fantastic Hottie Trust opinion. It turns out throughout that trial, he was using assistive technology in order to follow the trial. He had some hearing issues. He's an older gentleman. And of course, that issue in that trial was accessibility of, you know, learning material. Yeah. And I wonder whether Judge Evans was contemplating how nice it might be if she could access all of the material she needed at home as she was hobbling around
right.
in her injured state.
Rather than have to drive down to the library.
Yeah,
and check
right? This seems like a really valuable tool all of a sudden. Well, so Steve Schaetzel, I wonder then, so Steve, you're also on the legal team that represented Georgia State. I wonder if you could then summarize, let me give you the hardest job so far, summarize that 350 pages. And really, you know, there's kind of the nut at the beginning where she lays out that framework. And I wonder if you could summarize Judge Evans' framework, because that was what was really under discussion today.
I'll try. The opinion, if you've seen it, is the first 20 pages or so it deals with an opening issue of sovereign immunity. Interesting to us that we heard nothing about that today on the panel, no questions about sovereign immunity. She then gives a very, very good overview of fair use, and particular fair use in an educational environment. It is now mandatory reading for at least one class at Emory that I'm aware of, because it is such a good summary of fair use. And then she launches, with that as her background, into a very detailed factual finding of each of the 4 factors, where she looks at, for example, what the professor said was the purpose of the use, and then she looks at the nature of the work, factor 2, and relies some on what the parties agreed, and then maybe perhaps what a professor said. And then she, what you did hear a lot about today at the argument, she adopted in factor 3 what I think of and tried to get out today as an analytical tool. It was called a rule, a guideline, and several other things that I think are a bit of an overstatement. But that third factor analytical tool is that if you take more than one chapter and use that, then that factor could potentially weigh against fair use. If you take more than 10%, that could weigh against fair use. And what I did not get out today, where I give her a lot of credit, is my belief on what she did is there was evidence at trial that all parties viewed one chapter as kind of an okay amount. The Commerce Clearing Center Best Practices in E-Reserves document states that experts advise to take up to a chapter or less. So there was evidence, and we had certainly had people that used a chapter. So that seemed like an okay amount. But she also had works in front of her, reference works that were part of the, that had fewer than 10 chapters. There was one that had 5 chapters, another that had 6 chapters. Well, if you take one chapter of a 5-chapter book, just basic math, that might be 20%, it could be a little more. And that struck her, I think, as wrong. And so she also adopted this idea that no more than 10%. And if it wasn't that you couldn't take more than 10% or that you couldn't take more than one chapter, it was that was kind of a tipping point, if you were, for her in the analysis. If you took more than a chapter, she's going to have to be persuaded why. If you took less than that, it was going to be like, well, that was okay. And Judge Marcus today made a lot of that, obviously, at the hearing. But that was a key part. And so she would look at the amount that was used by each of the professors. And then finally, in the 4th factor, she looked at various things. She looked at, as we heard today, she looked at the permissions market and was there a ready market. She looked at, was there any lost sales of whatever book it was that was involved, and she found none. And she then, at the end of it, for each and every work that was involved, all 64 of them, she would say, there'd be a summary paragraph. So, I find that it's a published, nonfiction, not commercial, purpose for the use, educational, obviously. Factor 2, I find the nature of the work is informational, which it favored our side of the case. Then 13 out of some 48 times on factor 3, she found for us, and she found for them 13 times, and the remainder times on factor 3, the amount taken she found for us. But then when it got to the 4th factor, and we didn't get this out today either, it's kind of dangerous to do this because you're already second guessing yourself.
I know, right?
But one of the facts that I hope the court picks up on is 31 out of 48 times on the 4th factor, she ruled for them. She ruled for the publishers. And a lot of it was because of the permissions income, or the permissions license situation. So she put all that together and came to a decision and found that we prevailed on, we think of it as 94 out of 99 claims. There were 99 claims at trial. 10 of them, she found de minimis infringement. There wasn't enough use. The students weren't actually, this is a real surprise to me, but students actually did not read the works. It was very surprising. But then another, as you heard today, 43 of them she found to be fair use. 16 of them she found that they just didn't do the blocking and tackling to get the first down. They never got their prima facie case made. And then 5 of them were infringements. So based on that, she said we won on the central purpose of the lawsuit and awarded fees, and also awarded Dr. Cruz's fees. So that was the decision.